now and forever.
So, wizard
Another WJ was the king of Lokulili was another WJ was Jehu del them said the Quana Kele to money Kali Hoske Simubara Imaral quiz Imaral Matal Yakwana Finusu Wantanin Mabirutu Ahataradi Laki Itaraji Itaya Biderisu Itaya Bidilu Ahataki Azuma Biderisu Aklata Kuta Besabi Laki Mabdaya Laita Ashandugu Mara Sakit Sabi Amsugu Uwanze Gilas Yanu Umwan Yaus Yadumbed Madadugu Mara Sabi.
So, good afternoon once again, everyone. We're glad that you're joining us for this edition of our Author Spotlight event. This edition is a special one where we're focusing more on the practice of transitional justice within the continent. And so we're going to have a presentation of a forthcoming report on customary justice in South Sudan, to be presented by Ms. Agatha Ndonga. Sorry, I hope I got that correctly. She's the head of program for South Sudan, and she works at the International Center for Transitional Justice. One of our discussants would not be with us, Mr. Michael Warren. He just sent in a message that he's been deployed on a mission, so he's unable to make it for this event. So Mr. Duthie has graciously accepted to fill in the space for him. And so he'll also try to help us fit in within the context of our discussion on customary justice, two other reports that had been published by the International Development Law Organization and the International Center for Transitional Justice. Of course, Mr. Roger is the senior expert research for the International Center for Transitional Justice. So we are grateful to you both for joining us for this edition, and we are hoping that we have a very impactful session during this time that we're going to be having these discussions. So a brief introduction to our own center before I hand over the platform to the presenter. The West African Transitional Justice Center, situated in Nigeria, was created to help bridge the gap between the research and practice of transitional justice along the West African corridor and in Africa in general. And so the Author Spotlight event is one of our flagship programs where we try to disseminate evidence-based interventions that people are making, both from the classroom and in the field, in order to help provide the technicalities that are needed for implementing transitional justice on the African continent. And we're going to focus a bit on South Sudan today. And like we know what's been happening in Sudan recently, and in terms of the war, the crisis there, it's already having like a rippling effect, you know, the southern part, especially in terms of migration and stuff like that. And so without trying to preempt or further ado, I'd like to hand over the platform to Ms. Agatha Ndonga to help us lead the discussion. Thank you very much.
Thank you, Philip. Greetings, everyone. Some are having their morning, some their afternoon, some their evening. I am very pleased to be making this presentation and having my colleague Roger Duthie as my discussant or fellow presenter. And I hope we are having a very massive thunderstorm. So I hope that it doesn't disrupt us. It's quite noisy in the background. And straight to my presentation. In the interest of time, please allow me not to go into the genesis of the study. But to what I prefer to start with when it comes to discussing, or rather sharing, the findings of this study, and that is straight with the statistics. And this is because this South Sudan being the case study, is that 80 to 90% of South Sudanese prefer to have their disputes resolved through traditional justice mechanisms. And therefore, I believe that by sharing the insights that this study offers on the opportunities or the prospects that customary and informal justice does provide in the field of transitional justice. And there are several reasons that South Sudanese prefer to utilize this mechanism. The main one being, of course, that they are easily accessible, and this does make it inexpensive, not only because they do not need to travel long distances for hearings, but also because they resolve cases speedily. We find that it can take about a day or two, unlike in the formal justice sector, where a case can be held in perpetuity. But also they bring the victim and perpetrators together, and thus they provide an opportunity for both the victims and the perpetrators to share a platform. The advantage of this is that it does provide an opportunity for the perpetrators who are willing to seek apologies from the victims, but also for the opportunities to offer forgiveness. Of course, this does give it provides an impetus for reintegration of perpetrators in the community. The other advantage, or the reason they are preferred, is that the mechanism's accountability is considered as less punitive and therefore reduces chances for revenge, which, as we know, does cause revenge is the major cause of cyclic or violence in most communities. But also they use local languages, or what we refer to as the mother tongue. And also they are adaptable when it comes to resolving new forms of community disputes. But there's also a big reason why such a large population in South Sudan does rely on this mechanism, and it predates all the way to the pre-independence that saw the Sudan, that is the north, that is unfortunately going through a civil war, is that it systemically marginalized the South, including in a failure to establish adequate formal justice mechanisms, but instead relied on the British, Anglo-Egyptian, also British condominium government, where they had what they referred to as the 1931 Chiefs Court Ordinance. I will not delve into that, but allow me just to give a little background as to why this is important. And this is because this framework of the ordinance is that it established a simple hierarchy of courts which were headed by traditional leaders, but the ordinance named them as chiefs, and they were under the supervision of the British district commissioners, and they were allowed by this ordinance to exercise executive and judicial powers, thus acting as administrators and magistrates. The reason I say this is important is because this now framework created a hierarchy which is now laid out in the Judicial Act of 2008 and the Local Government Act of 2009 that is still applicable all the way from the national level to the states, to the counties, and to what is referred to as the PIAMs. These are just the administrative level that is below the county, and then all the way to the BOMA, which refers to a household. Now, the reason this field is receiving increased attention is not only due to what I said is their potential for restorative justice, but also because they have increasingly incorporated some elements of transitional justice. And the most politically sensitive is the accountability mechanism. And the reason I say politically sensitive is because in South Sudan, accountability is a very sensitive topic, but also is the result in immediate remedy through compensation, but also acknowledgement due to the fact that the perpetrator and the victim share a platform. However, a new challenge has emerged recently, and this is because the chiefs are, unlike in the past, where the communities chose their traditional leaders that then acted as the chiefs that presided over hearings to settle disputes, is that now the communities do not choose their leaders or traditional leaders anymore, but they are appointed by the state. Therefore, this does prove to be, it does result in perceptions of compromise, because according to the community, they feel that the independence and the impartiality is affected by the fact that the chiefs are at times having to bend to the whims of the political leadership that has appointed them, as opposed to when they were appointed, or rather nominated, by the communities, and the communities took charge of all the expenses, or what we refer to as the needs that these traditional leaders needed to execute their roles. So in the current status is that the chiefs then have to rely on the government for salaries, which are at times not forthcoming, and therefore the chiefs are forced to collect taxes that do not augur well with the communities. But overall, and besides that particular challenge of political appointments of the traditional chiefs, is the other level of a complicity that is increasingly becoming common, or has become entrenched in South Sudan. And this is due to the fact that the intercommunal violence is increasingly evolving and becoming more militarized over time. And this is because, as we know, is that the South Sudan, majority of the people do have arms. Actually, there are rumors that each household has at least 7 guns. Therefore, what we see is that the type of violence in South Sudan has mutated into what we refer to as large-scale violence, and which now the traditional chiefs have no choice but to address. And therefore, what we see is that while these mechanisms are not designed to address or deal with such extreme elements of large-scale conflict, and thus the emanating serious human rights violations that continue to occur in South Sudan, in practice, they are having no choice but to do so. And even though various parts of the country are relatively peaceful, there are still several others that are experiencing intense, and when I say intense, it means there are massive deaths and other, what I'm talking of, killings, abductions, forced displacement, destruction of property, what we refer to as crimes against humanity in the international, when it comes to international human rights law. And therefore, what, on the other hand, so while the chiefs are not supposed to handle this, they do not have a choice. Again, with this militarization, the legitimacy of the traditional leaders has significantly weakened. And in some cases, actually, more than countable cases, is that there are cases, and this, the study does delve into this, is that their chiefs are reported to at times face humiliation at the hands of armed civilians. But what we see, and I should have mentioned this probably, is that there are 2 types of categories of customary justice in South Sudan. We have the central authority system, which includes communities that are ruled by kings or a monarchy, but there are also those that are not under the monarchy. So what we see is that those that have a central authority still do have chiefs wield, or the kings wield, very tremendous power. And we have those where the chiefs decisions are actually respected, unlike in these other ones that do not have a central authority, where we see the chiefs have authority weakened significantly. But I prefer not to say that as challenges, but rather as opportunities that can be used to strengthen this mechanism, seeing as that they are the most preferred by the communities. And one of them is the fact that there's a need to have the continued training for this, targeting these chiefs, for them to be able to handle the range of matters, particularly criminal matters, but also to enable them to refer them to the formal justice sector, and therefore complementing the justice sector. But also there's also the need to have a clear-cut border between the cases that the customary and informal justice mechanisms can handle and those that should be handled through formal lawsuits. Also to balance the power between the traditional authorities or leaders and the youth who, as I've said, wield more power due to the fact that they are heavily armed. Again, we see the fact that even when the chiefs need security while conducting their hearings and in the presence of the youth, is that the same youth at times and in many areas of South Sudan is that they are more armed than the formal security sector. So that does provide an opportunity for the state to ensure that not only is the security sector armed, of course, now that brings us to the component of institutional reforms, but to ensure that this traditional justice leaders do have adequate security. There's also the need to have adequate infrastructure. Because what we see, and when this comes to record keeping, what the findings indicate is that most of these courts, if I may refer to them as such, is that they mostly operate under a tree, and therefore record keeping becomes a challenge. The most glaring one is the component of gender, what we refer to as gender discrimination and ill treatment of women in the study. South Sudan being deeply patriarchal, what you find is that you will have a sitting that is only presided by men, and it is meant to be handling a case that, for example, involves rape. And therefore, what we see is the cases where the parties to the case then end up having the woman who has undergone sexual violation being forced to get married to the person who has raped them, therefore exposing the need to train this kind of mechanism to ensure that they do not, this kind of discrimination and ill treatment of women is dealt with. Like I mentioned earlier, the lack of salaries and maladministration has resulted in a lack of motivation, and which though gives the chief status, it also means that they need to have a source of income in some cases where the community, when they feel that they did not have an opportunity to choose their leaders, is that they at times are not willing to meet the cost for these cases. There's also the issue of heterogeneity versus homogeneity. For example, when there's a homogeneous community, there's a sense of confidence in the customary justice system. However, challenges arise in a heterogeneous setup where different communities live together and a conflict between individuals from their respective communities occur. In such instances, we have one community fearing that one group might impose their customary law over the other, and that's the reluctance at times to utilize the customary courts. This has not been a case, but increasingly it has become a challenge, is the contribution. Like I said, in the past, these mechanisms did reduce cycles of violence. But what we are seeing is that, as I said, due to the militarization, we have some parts of the communities or individuals resulting to revenge when they feel that the outcome of their cases is not satisfactory, or when they feel that they do not have a recourse, and therefore they might resort to vengeful killing. South Sudan, in the past, there was the practice of blood compensation, where if, for example, a person was killed by one community, the other community would demand that the only justice they wanted was for that particular community. to compensate by either allowing them to kill a person as well in revenge, but in some cases, they would demand that they are compensated by, for example, if it was a youth, a man youth, that they are given a youth who then now they felt was adequate compensation. Also, we have now, due to the need to avoid revenge, is increasingly what we have, the practice of people-to-people peace conferences or reconciliation practices, where instead of avenging by killing someone, is that they prefer to slaughter. Bulls in South Sudan are very held in high regard, or when a bull is slaughtered, it is a sign of what we call guarantees of non-recurrence in the traditional setup, whereby they declare that the blood shed by the slaughtering of a particular bull that has been picked up by the community, is that it does mean that blood has been shed in place of the persons or the people that were killed, or person if it's an individual, and therefore there's no need to avenge that killing. So what we see is the practice becoming more and more having to utilize this the reconciliation processes of slaughtering an animal, which also a symbolism that they are not going to avenge. So towards my conclusion is that the application of customary and informal justice does play a key role in resolving disputes or mending or repairing relationships. And this includes in the context of overt conflict and serious violations, such as the case in South Sudan. And like I said, is because they incorporate some critical elements of transitional justice, and especially the component of accountability, but also reparations, mainly compensation, because this is given on the spot. In such a context, then it does provide an opportunity to develop a hybrid approach that takes all this complexity into account, but also to offer clarity, support, and guidance, especially to both the formal justice and customary actors, so that they play a complementary role. I will just, because the formal justice, or rather the peace agreement in South Sudan did recognize the important role these mechanisms or the informal justice sector does provide, and the role it has played in reconciliation and healing in the country, is that they have been given a specific mandate within the peace agreement. And this is to support the Commission for Truth, Reconciliation and Healing, and that is the truth-telling mechanism. And in this, it does provide for them to complement, to continue referring cases, but also that the Truth Commission is meant to play a role, or rather within their mandate, to work hand in hand with the specific customary and informal justice leaders. Sorry, therefore, it does give an opportunity for the particular communities and the truth-telling mechanism to address the micro-cleavages in a comprehensive way, of course, while ensuring that the basic transitional justice principles are applied. And specifically, these are inclusivity, ensuring that the process is victim-centered. As I said, the major component is ensuring that there's gender sensitivity, but also ensuring that the right to the truth is upheld by providing security to all actors, and also factoring compensation while ensuring that it is not haphazardly externally driven. So specifically, and I think this can apply to a similar context, is that, is where appropriate, ensure that they supervise such mechanisms, the formal transitional justice mechanisms. For example, in the case of South Sudan, is ensure that they supervise the proceedings of transitional dispute resolution, and especially foster reconciliation and healing. Also, to provide formal guidelines for these traditional and customary authorities so that they can adopt mechanisms that enrich, or rather principles that enrich their capabilities of resolving inter-ethnic conflict within set frameworks, that is of truth-seeking, like I said, accountability, etc. But also for formal mechanisms to supervise and, where appropriate, give guidance. But also, like I said, very importantly, it does provide the opportunities for enhancing the capacity of these traditional actors to handle, like I said, the emerging crimes against humanity that they have no choice but to handle. I think I'll leave it at that. And in case there are any questions, I'll be ready and willing to respond. Back to you, Philip. Thank you.
Thank you very much, Agatha, for your very elaborate discussion on the findings of this very important research. And I think this fits into a previous edition of our Auto Spotlight event, where we were talking, we treated the book, Justice During Transition, that was published by Odesha late last year. The authors were arguing for a tradition-based, they didn't call it traditional, but it's a tradition-based community-led initiative for transitional justice processes, which I think is what this research has discovered in South Sudan. Just trying to give a brief summary of your presentation. You spoke about the values that this process is adding within the South Sudanese context, and you're talking about it being cost-effective, the proximity of those involved to the location where it's being carried out, also the pace at which justice is being dispensed, and then the focus on restorative justice rather than the retributive aspects of justice. Of course, accountability came in at some point, so it's less punitive, and also the ability for people to relate based on the language, the mother tongue that is being used in the dispensation of justice. I think this is also very important. The reason why this is very valuable to the South Sudanese context, like I mentioned, is because of the pre-independence history in the nation, where being part of Sudan, they were marginalized. And so the legal framework or the legal institutions in the country at the time did not factor in the needs in the South. So I think these are very important points I mentioned. Also, looking at the current challenges, to the implementation, talking about arms proliferation, which creates a bit of security issues for people who are helping. You also mentioned that the chief may not be very familiar with other tenets, if I could use that word for justice, in terms of international standards. I have reservations about things like that, but for this purpose, just say they may not be familiar with it, and so they need training, which I think we would also try to elaborate on during the discussion session. Also spoke about reforms, the need for infrastructure, gender responsiveness in all of this. I think this is also very important in terms of trying to implement traditional. Oh, sorry. So apologies. It's like I'm breaking up a bit, but it's a very important presentation. And so I was talking about the challenges, and of course, diverse ethnic groups. The demand for blood that is being when sacrifice, demand for human sacrifice is being replicated by sacrifices. So let's just stop here and hand over the platform to our discussant, Roger, to take it up from here. Thank you very much for your presentation.
Thank you, Philip, and can you hear me properly?
Yes, we can.
Okay, great. Thank you, Philip, for hosting us, and thank you, everyone, for being here. and giving us the opportunity to speak. Thank you, Agatha, for that great overview of South Sudan. I would start just by saying that I think customary, informal, traditional justice is an issue that has been studied quite a lot certainly in a limited number of transitional justice contexts, like Rwanda, Uganda, Sierra Leone, Timor-Leste, and a few others. But overall, I think there really is still a need for more empirical case studies and empirical evidence on the issue, and I think which is what makes a study like Agatha's so valuable. In my capacity, I've worked on the issue in a number of different research and policy projects on different topics like demobilization and reintegration programs, children associated with armed conflict, displacement and sustainable development. And I think the issue is continues to be a critical one for the field of transitional justice overall. I'm going to step back quite a bit and try to situate the issue of customary justice within the broader framework, not just of transitional justice, but of transitional justice and its relationship to sustainable development, which is admittedly about as broad as it gets. So I'll try to make some relevant connections. I'm going to speak from, Philip mentioned the two reports. I'm going to speak from the perspective of the working group on transitional justice and SDG 16 plus, which is an initiative that includes members of civil society, national governments in a number of countries, and some international UN bodies and international and regional organizations, which basically have come together to try to persuade relevant policymakers and stakeholders of the value of transitional justice to the 2030 Sustainable Development Agenda, which of course is a very broad agenda that includes things like equality, peace, and justice, among many others. In the absence of of Michael from IDLO, our other discussant, I'm also going to mention the report of the working group on customary and informal justice in SDG 16 plus, which is a similar and related platform which frames customary and informal justice as a critical part of people-centered justice and generally as part of efforts to close the justice gap globally. As Agatha mentioned, in many contexts, most people's access to justice is in fact through informal justice and not formal systems, so that that working group really conveys the message that there's a need at the international level to recognize and engage informal justice more, acknowledging its risks and problems and working with community groups to make sure that it is as inclusive as possible and protects people's rights as much as possible. Returning to the working group on transitional justice in SDG 16 plus, the premise of our work on the report that we published and was shared really is that the legacies of serious and massive human rights violations can create significant and long-term obstacles to individual and collective well-being and capabilities, and that by addressing things like harms, losses, destruction, marginalization that victims and communities experience, that transitional justice can in some ways help to reduce those obstacles. The experiences and the research that we draw on suggest that some of the specific ways that it can make a contribution are by increasing people's agency, rebuilding social relationships and trust, and helping to address and draw attention to some of the drivers of violence and exclusion. And in particular, helping to prevent the recurrence not just of violations, but of violence more broadly, by helping to respond to people's and communities' grievances and fostering inclusion and reform and other changes. All of this, we argue, makes transitional justice relevant to a range of SDG targets, including access to justice, rule of law, violence reduction, inclusive institutions, and so on. This is all in theory, but of course, it all depends on the way in which transitional justice is designed and implemented, and the extent to which, for instance, that transitional justice processes are participatory, that they're contextually appropriate, that they're innovative and flexible. And these are areas in particular where I think customary and community level justice processes play a really important role. Still at the level of international policy, this kind of the general relevance of transitional justice and addressing the path to development by this point has been recognized, I think, by a number of important international policy bodies and actors like the UN Human Rights Council, like the UN Secretary General, the Security Council, the Secretary General's new guidance note on transitional justice, the special rapporteurs on transitional justice, as well as the African Union and the European Union, some of which have specifically framed transitional justice as a strategic policy tool of development. And I think the AU is pretty direct in this sense, recommending that transitional justice should be thought of as a development measure meant to rectify structural inequalities, marginalization, and exclusion, and achieving social justice, which I think is one of the more direct ways of framing it. Again, in practice, though, we know that things play out differently, and in many cases, I think there are many opportunities to try to better integrate transitional justice into development agendas. Reparations programs, for example, can provide social services and infrastructure to victims and communities. Livelihood projects can incorporate psychosocial support for victims. Truth-telling processes of different kinds can lead to recommendations for broader economic and social reforms. These are all things that I think clearly have a direct bearing on sustainable development, but could be better included in development plans and policies and reporting at the national, at the local and national levels. The report that the Working Group on Transitional Justice put out in 2023, in that we make a number of suggestions for trying to bring about a bit more of this type of integration. And these are, of course, very broad, but we can discuss them in more detail. The first one is increasing collective action among victims groups and networks and civil society, and in particular making connections to broader social and political movements to try to generate the advocacy and the mobilization and the support that's needed when you're trying not only to respond to immediate harms, but trying to contribute to transforming broader structures as well. The second one is incorporating transitional justice into responses and interventions at multiple levels, not just the national level, but the local, the regional, and the global as well, and through formal and informal institutions, which I think is critical to making, more effectively addressing the scope and the complexity of many of the development problems that we're talking about, the dynamics of which don't just happen at one particular level. The third one is adopting a longer perspective on the implementation and impact of transitional justice, which I think is important to both to maintaining the support and engagement that is needed, but also really understanding the actual contribution that it can make to broader goals. It's the second of these, the need to address complex problems like intercommunal violence and displacement at multiple levels, where I think customary and community level responses come in particularly clearly. Transitional justice often tends to be thought of mainly as a national level initiative. But we know from the examples of countries like Colombia and Liberia that efforts can be made to include the perspectives of victims and refugees who are outside of a country. And we know from many contexts that I've mentioned, like Sierra Leone and Timor-Leste, but also the Philippines and Northern Ireland, that community level processes can be critical, particularly to processes like reintegration of former combatants and the return of displaced populations and groups to communities. And here I would return to try and highlight one of the things that both Agatha and Philip mentioned, which is that the customary and community level processes often include restorative justice principles and practices, including direct encounters between not just victims and perpetrators, but also communities, as well as alternative sanctions, alternative to criminal sanctions that can really play a role in sort of shifting the emphasis of the effort away from punishment and more towards things like reintegration, and in some cases, actual local development projects. This is something that's highlighted at the community level, but is not necessarily limited to the community level. We know in recent the efforts of the Special Jurisdiction for Peace in Colombia has made an effort to integrate restorative justice practices into what is really a national institutional and judicial process. Finally, returning to the South Sudan case, I think one of the most important points that Agatha concluded with was that transitional justice framework can really play a role in providing some clarity and guidance on the specific role of customary and local processes, which in practice is not always clear, especially in the really complex contexts like South Sudan. And this speaks to a point which is made in the Customary and Informal Justice Working Group report, which is about fostering the need to foster coherence in justice ecosystems. So really thinking about these things as ecosystems and how they work in conflict-affected contexts, which means making multiple pathways to justice available and navigable for people, for making connections between different justice actors and providers, and really helping us to see how these things can fit together. And I think this notion, the Truth Commission, which Agatha mentioned, playing a supervisory role, a specifically mandated supervisory role, is a really good example of trying to foster that type of coherence. And I think this idea of coherence is the right way to think about customary and local processes from a transitional justice perspective. So I'm going to stop there. Thank you again, and I think we are looking forward to your interventions and experiences and happy to continue the conversation. So back to you, Philip.
Yeah, thank you very much, Roger, for your wonderful intervention. This has been a very eye-opening session thus far, and we thank you both. But if I could crave indulgence briefly, as a community, we wish to recognize the presence of Professor Lutai Adesina. And the reason behind this is that he was awarded recently the Global Professorship by the British Academy and is with us today. So we congratulate him as a community and wish him the very best. more importantly, his work on decolonizing social knowledge is something that I think could factor in the traditional aspects, especially in terms of customary measures for dispensing justice. So we're happy that you joined us today, Prof. So just to try to create a brief summary, and also to tell persons who would like to make interventions that you could either type your questions in the chat box and we'll take them, or you could signify by raising up your hand that you want to speak, and we'll allow you to speak. So just the key points of Roger's presentation before we open the floor up. I think he spoke about how legacies of human rights violations are obstacles to individual and collective well-being and development. And he also told us about the role of international organizations and regional bodies in framing transitional justice as important structures and as an important tool for managing post-conflict contexts today. He also tried to create a nexus between certain aspects of transitional justice, like restorative programs on restorative justice, livelihood projects, and of course, truth-telling, as tied to certain aspects of sustainable development. So he admonished that we have to look at the long-term plan of TJ processes in order to make them a bit more effective. And he concluded by telling us about certain coherence as is being conceptualized within the justice ecosystem. And this is where we can fit in some of these customary measures into the transitional justice and other judicial mechanisms, within different contexts. Thank you very much. So I have Emmanuel Chidoze's hand up. So Emmanuel, you could make your contribution. Thank you.
Okay. Thank you very much for this beautiful presentation by the presenter. I was wondering, when you talked about sacrificing or using a bull in replacement for avenging a human person or killing another person in exchange, I was wondering, how will you now speak to those that are very conscious of animal rights, and then not only of animal rights, this whole essence of also climate justice? So how does this informal customary law or tradition speak to this animal rights and also this climate justice that is all over the world, especially in this period in time when people talk about animal rights? So thank you.
Thank you very much, Emmanuel. I think you can respond while we wait for other persons to answer to ask their own questions. Yeah. Agatha, you have the floor.
Yeah, okay. Thank you, Roger, for your presentation as well, and Emmanuel for your question. As I mentioned, one of the advantages of the customary and informal justice sector is the issue of adaptability, and the fact that they are able to they easily adapt to any new cases as they emerge. Case in point, of course, as they shared, was the fact that they have had no choice but to adapt and preside over situations where we have massive killings, even when they are not equipped to do so. I would think that this is the same case. And when it comes to the issue of blood killings, and I hope you can hear me, the thunderstorm is just rumbling at my back. The issue of you can hear me? Okay.
Yes, we can hear you. Yeah.
All right, thank you. So the concept, or rather the practice of slaughtering the bull it has always been arrived at, or rather is always arrived at by the communities. And the reasons for this is to reduce the issue of vengeful killings, where, like I said, is when a youth is killed by a community, then the community that has lost in the past would resort to killing, demanding that they kill a youth from another community. If it's a woman that has been raped or gone through some sort of sexual violation, is that the community where this woman has been, that has experienced a sexual violation, would demand to be given a woman to also violate, or even without demanding, they would, of course, attack the other community and rape as many women as possible. And so the concept of killing a bull in place of this was some sort of reconciliation, and it is still a practice to date that has become very common, but due to the fact that it has reduced the vengeful killings. So when it comes to the issue of climate change and animal rights, I would want to believe, and this is not something that had been preempted, or neither did it come up in the study, is the fact that due to, like I said, the issue of adaptability, or the element of adaptability, but also playing the complementary role, is that I presume this is something that then would be handled by the formal justice sector. And I think this is something that would really, that should go into the guidelines that I mentioned, or the standard operating procedures that are meant to guide the operations of the customary and informal justice sector as they play the complementary role, both through the transitional justice mechanisms, but also within the formal justice sector. And I hope that I have responded to your question adequately, Emmanuel.
Sorry, just to make sure I get you correctly. So in terms of, although I do not want to call the animal rights a Western concept or idea, but what I can get from what you're saying is that there is room for improvement and adaptability. But to what extent will that kind of adaptability, that is speaking pragmatically, make sense? Because if, for example, it's okay, they shouldn't kill a bull because of the blood, so what can they use? That I'm just theorizing, just more of a hypothesis. What will you now suggest they could use in place of it? That is, if you believe in climate justice or animal rights.
I certainly do, and I like that the opening up of this concept to more thinking. As we know, the customary and informal justice sector is very community driven, and as you said, at no point, and as I mentioned during my presentation, the reason at some point they face challenges is when they feel that there's imposition. And the fact that you mentioned that the climate change and animal rights is very, according to communities back especially in the global South, is that communities will not only slaughter a bull or a goat during ceremonies, but they do not, the concept of animal rights is yet to get to that level. And therefore, the fact that they do not want imposition of and they make it very clear, is that when they feel that there's imposition, they will always they will retract, or rather they will not support, or rather they fail to support, or they withdraw, actually is the word I'm looking for. They will withdraw from whatever mechanism, and they will ignore it. And case in point is where they feel that if a chief, and in like I said, the two setups where we have the monarchy and the non-monarchy, and where the king, they still choose their kings, and the kings then will preside over this or appoint the persons to preside over the hearings, unlike the ones where they do not have, and in the situation where a chief or a traditional leader is imposed upon them by the government, they will almost always not appear or have their cases referred. They prefer that their cases are attended to by the chief that has been appointed by the king. And therefore, I would want to think this in terms of that kind of practice, that they will not say no, but they will also not support, and therefore they will avoid practices or where they feel it has not been from their own practice or that has been imposed upon them.
Okay. I don't know whether Roger has anything to add to what I said.
Not much, just to briefly say that I think the point, as Agatha rightly has articulated, that it speaks to the kind of tricky question of, what do you do to with local processes and community-driven processes that are perhaps problematic from certain standpoints, and without imposing change from the outside, which is not going to be sustainable. And it raises questions from a government standpoint, from an international standpoint, about, what type of do you engage and try to change the practices, or do you just not engage and not support? And if you are trying to engage them, how do you do that? Is it directly, or is it working through other community groups and actors who are not necessarily part of these processes, but maybe more better positioned to reform them in a more sustainable way? I don't know what the answers are, but I think the question around animal rights, if you're advocating for animal rights, then this may be a problematic thing. But how do you go about changing these processes is the bigger question that I think it raises. So thanks.
Yeah, thank you very much. If I could just, I have a question, but just to add to the conversation that is ongoing, I think from my own standpoint, I think I view the replacement of human sacrifices with animal sacrifices as a sort of progress and already an adjustment, from what used to be. So if I could ask him, which would you prefer, they killing humans or they killing animals? So for me, and that's where I stand, to say that we cannot also, we have to define what we mean by the right of animals. At times it could be the manner in which these animals are killed. It could, in the absolute sense, be killing them at all, but I think we need to also treat concessions in trying to accommodate some of these practices that are working for the people. I think the goal should be something that we focus on more at this point than other judgmental values. This is just a very personal opinion, and as long as this is done within the community, is a bit is accepted and it adds value. I think over time there may also be some changes, but there's a significant change already, in terms of this practice from my own standpoint. And my question is this: I think during Agatha's presentation, she mentioned about the role of traditional rulers, and at times there are always conflicts between the formal institutions, the Court of Justice and stuff like that, and the role of the traditionals when they try to carry out mediation or arbitration, in the communities. Now, you advocated for training, and I think one of the disappointments I've had in life was to listen to a traditional and train them mediation and arbitration. The reason why I'm saying this is that from the civil society point of view, it might be right, but I also felt that these people, as custodians of the culture of the people, are supposed to be knowledgeable about what it entails within these customs. I'm not saying that everything they are doing is right, but I'm saying in order not to, from a reflexive point of view or from a distancing point of view, it's important that we try to give ownership or leadership positions to some of these rulers or some of these traditional stakeholders in driving the processes themselves. The danger I see with training is that we may alter some core components of some of these practices that actually lead to sustainability in terms of peace and also development. I don't know what this is my, and I'll try to just practice through governance. I think that governance is something that is supposed to be incorporated into the transitional justice process itself. And I think that there's a bit of neglect when it comes to what happens within the post-conflict democratic systems in terms of, I don't think governance is taking that, we just leave it at the normal practice of elections and stuff like that. And I think it has not been as effective. I think that's what a lot of people or scholars, at times commentators, have said is that the same set of people are being recycled in government, you know, even during this already, or in these transitioning societies, in fact, and that's why the transitions are often never complete. You know, so what's your view on trying to incorporate traditional institutions into the governance architecture themselves, like some countries do, and like it was in practice in the immediate post-independent era? I remember that in Nigeria, the governors of different regions were actually traditional rulers, you know, in all of these regions. Maybe I'll just start, but what I'm saying is, how do we incorporate traditional institutions into the governance architecture within post-conflict societies, you know, in order to make them more effective? I don't know whether that's clear, so I'll just stop here.
Okay. I hope that I got it right, Philip. You are breaking up a bit. So your question is how to formalize traditional justice into the government or formal institution structure, civic institution structure, right? Is that
yes, sort of.
Okay.
Yeah.
Okay. All right. Thank you.
Yeah, that's it. And how to also make them, in terms of training, how to alter the core components of these traditional practices themselves when we say that we're going to train them, you know, how not to just impose. Yeah, sorry.
Okay. All right. Okay. So I will go back to the part that I said, the importance of the acknowledgement or the recognition of again, giving the case of South Sudan, is the fact that they were recognized in the peace agreement, and that is the revital, both the peace agreement that was signed in 2016, there was an agreement for the resolution of conflict in South Sudan, but also in 2018 when it was revitalized. And the fact that in these two frameworks, the traditional mechanisms were recognized as have continued to play a role in South Sudan, even way before independence. And the fact that even this recognition is actually meant to morph, hopefully, into once, you know, they get into, because what we have currently is the government of national unity that came together, that was put together from this peace agreement, and that is meant then now to transition into a democratic government through elections in December. Hopefully that this will happen. And so what is expected, as I mentioned, is that there's meant to be the drafting of guidelines that will then formalize, for lack of a better word, having these traditional mechanisms recognized formally, and such that their rulings or rather decisions for, if I may use that word, is that it is meant to be binding. And therefore, if someone from the society feels that the decision does not favor them, instead of revenging, is that they can actually take this case up for hearing, or rather recourse. They can seek recourse in the formal sector. And these guidelines, as we all know, usually they are regarded as some sort of policy. The only thing that they need is for them to be then assented to by the authorities. And just so allow me to give an example of just how in the case of South Sudan, how I feel that the practices, or rather the preference for these mechanisms, are still held in such high regard. As recent as last year, a case that had been presided over by the traditional court that involved killings was picked up by the states. I guess because the state also felt the need to they felt that the communities were taking the cases of killings lightly. And what happened is that the case was brought up in the formal justice sector, and the particular person, the perpetrator, in this case, was jailed. And what we have is the communities actually going to the courts to demand that this youth is released by the community, both the communities that had lost their youth, but also the community whose youth had been jailed. And they demanded that they had already settled this case, and therefore the formal justice sector has no reason to interfere. Another case is where a lady, as we know, most parts of the South Sudan do have arranged marriages, is that a lady was married off to a gentleman that she did not want. And what she did is that she fled home and she fled from the husband, the imposed husband, if I may use that word, forced marriage in this case, and she went back home. And the father took her back to the husband. And the lady went and reported this case to the chief and demanded that she wants her case scaled up to the formal justice. But the chief said, can we have the two disputing families come together and we resolve? And the lady said, no, I do not want to be married or forcefully to this gentleman. And she went back home. Her father, together with her husband's family, ended up gouging the lady's eyes. She's now blind. And the case being that they did not want this case handled by the formal justice, and they felt that is the only punishment. And the two communities have decided they're not going to appear because they were prosecuted. Her family and the husband's family have been prosecuted by the prosecutor in the government prosecutor. And so what we see is, of course, now the need, like I said, to train these customary leaders into understanding that there are criminal cases that do need to be handled by the formal sector. And this being that that is the only way there can be deterrence, especially in cases where now these practices then end up being more harmful than helpful from following those two examples that I've given. But that said, is that part where I repeat, allow me to please, is that there is now that provision that there's a need to draft guidelines and standard operating procedures that are meant to if I may use the word integrate, like Philip, you have written, into what now we refer to gradually as the country transitions into a democratic state that is meant to have formal mechanisms that are rightfully, as we say, or trained to handle such matters professionally. Not that the traditional ones are not professional, but the fact that they, in such particular cases, you cannot, even if they give cows or slaughter bull, the lady's eyes in this case will not, eyesight will not be restored. And in the case of the gentleman that was killed, is that he will not be, there's no, you cannot fully compensate a killing, or in this case, such kind of assault. I hope I've answered your question correctly.
Yeah, you did. But if you can hear me quickly, I wanted to find out the removal of the eyes, is that like a judicial measure from the customary, or was this like a violation in itself?
Absolutely. It's an assault. It's a bodily, I would call it gross bodily harm. And it does demand that, the perpetrator must face, be held to account for that. And of course, it does fall into the category of a criminal case, in my view. Yeah.
No, but I'm saying for the community members, they didn't see any reason to punish this act from their own side? This is the question, sorry.
No, according to the community, the lady is flouting the traditions, and she is not supposed to. According, like we said, not all practices really are, are correct or right in my view. Some are harmful. And remember, as I said earlier, that one of the biggest challenges that we've had with this, in my view, is the fact that the South Sudan is still a very patriarchal society. In this case, the lady, there was no woman involved in the hearings, at least to represent, to ensure that the hearings are gender sensitive, and that a woman would speak and express how a woman in this instance feels. It was male, it is the men that decided that, she's flouting the traditional practice and she needs to be punished. And she doesn't have a say because, once you're married off, the man has paid a lot of, dowry in South Sudan is still in forms of cattle that the family, the gentleman's family or the husband's family has already paid dowry to the lady's father, and the father did not want to return the heads of cattle that had been paid as dowry. And therefore, this was actually to them, what they say is that it was not only meant to punish this lady for causing embarrassment to the community and especially her family, but as a warning to other ladies in future that they must not think of doing something similar. So to them, to the community, this is a very harm. It was meant to be a deterrence, but when we come to human rights, of course, it's a gross human right violation that needs to be punished.
Yeah. Thank you very much for the clarification. Before we take Max, I don't know whether Roger has something quickly to say.
Just very quickly to follow up in response to the question about integration. How do we integrate these things? I mean, I think there are different levels of integration, and there are things that can be not quite, you don't have to be fully integrated to have coherence. So Agatha mentioned the peace agreement, and there are, legislation that can sort of formally either integrate traditional institutions or local institutions, or just recognize them and come up, provide guidelines on how different institutions can work better together. Either way, I think in practice, very often what actually happens will not be entirely clear, and there will be institutions at the local level dealing with things that they aren't supposed to be dealing with. And so I think that's where, in practice, you need not only the kind of formal integration and recognition or legal integration or recognition, but you also need these institutions, whether it's a truth commission or the creation of a different body, to try and give more specific guidance or make these things function more with more coherence, to return to that word. And the Truth Commission in the South Sudan case, to me, a really good example is the idea of the Truth Commission and the traditional authorities working together to refer cases to each other, to decide that the traditional authorities can decide this case isn't for us. We are going to refer it to the Truth Commission, and the Truth Commission can say, this has come before us. Well, this is a topic that the community can deal with on its own. And I think that's in practice, how that's going to turn out, I don't think we know, but I think it does demonstrate that you need something, a mechanism to play that role, which doesn't have to be full integration. It's just getting these things to work, making connections between the institutions and how they function. So thank you.
Yeah, thank you very much for your wonderful intervention. Max.
Hello, can you hear me?
Yes, we can.
Yeah, sorry, I cannot put on my camera now because of where I am. My question is to Roger. He did mention alternative sanctions. That's something I'm particularly interested in. I wanted to know what are some of those sanctions and how can they actually be implemented in transitional justice without necessarily affecting the ordinary people? Okay, so are the effects going to be quite different from the sanctions that we've known for some time now? What are those sanctions actually?
That's a great question. Sorry, go ahead, Philip.
No, you can't. Okay, I thought there was a question in the chat that we could take, but I think the person is just asking for the South Sudan's guideline, whether it's public and can we have access to it? So you can just take both together. Yeah.
Agatha, I will let Agatha talk about the South Sudan guidelines, and Max's question, I think, was to me, and I can answer that. But Agatha, would you?
Yeah. So the guidelines are not yet drafted. It's meant to start once the commission is put in place, because it's meant to be the commission, the truth-telling commission, that is meant to take the lead in that. So they are not yet in place. But what we have, the ICTJ intending and has already put a proposal, is to draft the first set, or rather prepare the first draft, and share with the Ministry of Justice as the ministry that is mandated to undertake this, to take the lead in this. And therefore, we are already having the conversations on that. And we are hoping that the draft that we share, if not fully adopted, that at least most of what will be shared, will be adopted, will be borrowed from that. And I'll add that, the reason we have proposed to provide technical support is because we draw from our global comparative lessons from the various contexts that we have worked in globally. And therefore just want to harness that wealth that we bring together to prepare this.
I'll try to respond to Max's question about alternative sanctions. I mean, I think, it depends on the context. Whether it's a kind of community level informal reconciliation process, there can be different types of projects that a perpetrator can be told to contribute to or take part in. I mentioned the Colombia example, which is a formal, institutional judicial process. So it's a little bit different, but I think it's instructive because there the alternative sanctions can include if someone who's accused participates in the process and admits to what they've done and admits responsibility, acknowledges their responsibility, they can receive a combination of alternative sanctions, which include reduced prison sentences. It can include restrictions on their movement or, what the practices they're allowed to engage in. And it can, the link most interestingly, I think, and here the connection with more informal local processes is actual participation in a local community development project. And, in the Colombia case, these haven't been implemented yet, but there have been proposals. The perpetrators in this case are supposed to make the proposal for what the project would be, and then the victims and the communities have to accept it. And I think in theory, this can be a very productive thing. It can contribute to the reintegration of the perpetrators, and it can help provide some sort of redress to communities. In practice, I think it's difficult. It all depends on whether the accused actually goes along with and implements the sanctions. It depends on whether the victims and the communities feel that they have done this adequately and that the sanction is connected to the actual crime. So in practice, I think there are a lot of challenges related to it. But yeah, I think that's the general idea of moving away. And I think this is within the framework of restorative justice, which we've talked about, restoration, which is moving away from criminal criminal sanctions and prison sentences and towards more productive things. And having said there's not a great deal of experience like Colombia within transitional justice settings, there's a lot of experience within restorative justice practices in many communities. And Northern Ireland is one of the examples that I think is very useful in terms of communities embracing these processes with former members of paramilitaries and former fighters, and working with them at the community level to productively contribute as part of their acknowledgement of responsibility. Agatha, I don't know if you want to go into any of the specific. We've talked about some of the problematic sanctions and practices within some customary settings, but I would let Agatha speak to that if she wants.
No, actually, Roger, you have exhausted, and also the few examples that I gave, I hope are adequate.
Okay, thank you very much. As a way of wrapping up, I didn't want us to miss out on this. How best do you think these customary justice procedures and mechanisms can be funded, in order to make them very effective? Because like I think during Agatha's presentation, we heard of how the funds are not coming and these people have to start taxing people for survival and stuff like that. Yeah.
I'll give it a shot, and if Roger has something to add, please do so. So to go back to how they were initially, the customary processes were funded or survived, or is that I'll give an example of if most of the communities, and I give this because this kept being one of the examples that were given, is for example, if two a married woman and a married man were courting, a case was brought where they have been having a relationship, extramarital relationship, is that both the lady and the gentleman were meant to bring 7 cows each. They still they still use cows and because it's still a very what do we call it, barter trade society. And so they would have, both of the parties, both the complainant and the other party would have to bring equal parts of what would be needed. And what would happen is that in case, of course, after the decision is made, is that this the cows, then the chief or the traditional leader was at it was at his discretion. The cows that were brought were meant to actually be like some sort of payment to the chief, and did not form part of what then would be used as compensation. So what we see is that the communities then would be the ones providing support to these customary processes. But in the cases where now the chief then is appointed by the government, it is expected that the government is meant to provide the resources that are needed to conduct these proceedings or hearings. But the reason they have been challenges is because not only has the government been failing to provide salaries or remuneration for the leaders, but also in providing the resources that are needed. And therefore that is what I was referring to as a challenge that has resulted in some sort of weakening of these mechanisms. So to answer your question is that if they are to be, fully operational, there's then a need for the states, if they indeed do feel that they should continue appointing these leaders, is they should adequately provide the resources that are needed, and especially monetary funds that will enable the mechanisms to continue without interruptions, but also to ensure that the chiefs are adequately salaried and provided adequate security such that they are able to undertake their mandates properly without having to feel that the societies are looking down on them, because this is one of the biggest reasons that the communities have started looking down upon the traditional leaders, especially in the cases that I said, the ones that do not have the monarchy kind of leadership.
Roger, do you want to add anything?
Nothing to add, thanks.
Okay, yeah, thank you very much. So I think we need to wrap up. As a center, we're very grateful to you, Roger and Agatha, for your time. Of course, through the planning process that took some time and that you accepted to share your wealth of knowledge with us. It's been a very impactful session, and we're very grateful to you. We thank the members of our community as well, who joined us at a shorter notice than we usually give. Most of them are gone, but we are happy that some of you stayed with us till this point. We're grateful, and we hope that you join us for subsequent session. We also wish Michael Warren the very best in his mission, and hopefully we're able to work together, for the future. So thank you, everyone. We hope that when the report is available in the public space, you share it with us so that we can disseminate to members of our community to learn. And we thank ICTJ for the very important one they are doing on the continent at the moment. And we hope that the impacts will be felt, across the different regions in the continent. So thank you, everyone. And Okay, I think Sarit is trying to share something, but I think we can read that up ourselves. But I think we should wrap up now. So we thank you. Said fees for elders in community levy and customary mechanisms exacerbated the exclusion of women from such processes. Okay, because they may have been economically disenfranchised. So that's one of the disadvantages of levying people. Okay, that's very much understood. So thank you for sharing that with us. Thank you for also joining us for this event. We hope to see you in the subsequent editions of our programs. And without further ado, wish everyone the very best for the rest of the day. So thank you very much and see you.
Thank you, Philip. It was a pleasure. We look forward to more interactions in future. And thank you, Roger, and everyone else for taking part.
Thank you. Bye, everyone.
Thank you again, Philip.
Yeah, thank you so much. Yeah.
Thank you, everyone.